the ongoing proceedings inside of a Barrow County Superior Courtroom where the trial of Colin Gray, the father of the accused Apalachee High School shooter, continues as we monitor a live signal from inside the courtroom. You see it on your screen right now. We're going to bring in Joshua Schiffer, a practicing attorney and a legal expert. Joshua, you have been with us before. We're glad to have you back on. As you have been following along with the proceedings this week and in the last couple days, what has stood out to you from inside the courtroom?
Well, the professionalism and the level of discourse and decorum that we're seeing is reflective of the seriousness of this case and how well prepared not just the court is, but all of the litigators. This has been an extraordinarily professionally presented matter. And that's because, as important as the facts of this specific case are, it's the impact this case is having on national conversations that the larger audience is watching. In discussing this case, the predicate case that really was the first in the nation to use this theory of third party responsibility, criminalizing the duties of firearms owners out of Michigan, the Crumbly case. Now we're here. The nation's Second Amendment infrastructure is very much watching this, as well as the standard criminal defense universe, because this represents an expansion and extension of state prosecutorial abilities and discretion. Our local county prosecutors, district attorneys, are the highest constitutional officer in the county and are responsible for determining what gets prosecuted under state law. This effort is novel but important because it's holding Colin Gray, apparently or allegedly responsible for the actions of that third party child, using Colin Gray's constitutionally owned firearm. And so we've got a number of varying responses that sometimes are a little bit untraditional. I have people that are very conservative, supporting more progressive positions, and vice versa. That's what makes this case so unique and important. The first week has been very professional, and we kind of saw that from Judge Prim initially setting aside a couple of weeks for voir dire or jury selection, and they finished it by Wednesday last week and then had 2 days to litigate some other pretrial matters. This week, we have not seen pounding of fists. We've not seen yelling and screaming and raised emotions other than the emotions of loss and sorrow. The state has done an exceptional job using this first week to set up the picture, to paint what happened on that day when Colt Gray allegedly appeared at the school and committed this horrific crime. We haven't heard the specific linking and argumentative responsibility duty argument from the state against Colin Gray, but what we have seen, especially capped off by today's testimony of Grandma, we have seen numerous opportunities and examples where third parties such as law enforcement, schools, family members told Colin Gray, hey man, there's something wrong. You need to do something. We're waving the red flag. Do something. And we all know that he didn't. And that's the real key question this district attorney's office is asking the jury. Is not doing anything illegal. They feel that it was because of how much notice Colin Gray received, his lack of action, and then the ensuing massacre
And
at the
Joshua,
school.
and not to cut you off, but a question here for you, because the prosecution, as you've aptly laid out, is trying to make this case that Colin Gray had sufficient warning that something bad would happen. And despite having that warning, still provided his son the firearm that was allegedly used in this shooting. The defense, I am sure, and as we have seen through some of their cross-examination, is attempting to poke holes in that theory, making the argument, correct, that perhaps, in their view, Colin Gray did not have sufficient warning. He had some warning, but it doesn't rise to the level of something that would trigger criminal responsibility.
Yeah, that's absolutely been the effort of Mr. Hobbs and Mr. Barry, who are two of the finest lawyers the defense has in the state of Georgia. They are literally legends in the criminal defense universe. And you've seen very specifically how those holes are getting poked, because the state needs a jury to say that Colin Gray was given so much warning and so much notice he had to have acted. And a failure to act would for anybody cause a crime, because that's what the jury is charged with. As the state put out at the very beginning of their opening on Monday, this isn't a case about what Colt Gray did. It's not. This is a case about what Colin Gray did, and more importantly, what he didn't do, his restraint in failing to act in a reasonable way to protect other people. And that's how the logical connection with the cruelty to children, which then leads to the murder, which is necessary in order for the Georgia courts to sustain a conviction. Because we all know, regardless of what the trial court does, this case is going to be appealed one way or another. It's too important to the state, and it's obviously very important to the Gray family.
Josh, I want to circle back to something you mentioned a little bit earlier in one of your answers. You brought up the Second Amendment component of this case and this conversation. The Second Amendment, the constitutional protection of an American's right to bear arms. This is a case that is about a school shooting. It is a case about the father providing son with a firearm allegedly used in that shooting. But I want to ask you, how much of the actual legal arguments in the courtroom are focused on the gun versus how much are they focused on a parent's potential responsibility? In other words, if the question was that the parent knew that their child was a dangerous driver and provided them the keys to the car, now we're talking about a vehicle as opposed to a firearm. Is it really about Second Amendment, or is it about this negligence theory?
That is the conversation that the defense really wants the jury to have. And in setting out the rules and pathways the state and the defense are going to ask the jury to ascribe to, making this into a political case or not making this into a political case, that's a defining issue. The state understands that the Second Amendment is kind of kryptonite with juries. You can't predict what a typical or assumed juror is going to believe when it comes to the Second Amendment. There are very strong opinions when it comes to constitutional issues, including some really counterintuitive positions held by people who firmly believe that, nope, if there is any mention of a firearm, it's going to violate the Constitution. And then, of course, you've got many people urging nationally for changes in our Second Amendment and gun control regime. Those issues are a wild card in any jury room. You don't know how juries are going to have their own dynamic, because each jury is absolutely unique because of the personalities involved. And you can't predict. Every good lawyer has lost juries and won juries that they shouldn't have because of those unique dynamics. So the state wants to keep this away from being a Second Amendment issue due to the volatility. The state wants to make this a personal accountability, rational discussion, where if you have something horrifically dangerous and you are the last and best person to prevent that very dangerous item from being used by someone you have been told is dangerous, that needs to be a crime. And that is outside the crimes that we've previously considered. But again, this jury, most of these jurors have probably never sat on a jury before. They've never been exposed to the criminal justice process this intimately. So they may not even realize quite the depths of what they are being asked to probe. The defense wants this to be an argument about guns. The defense wants to cleave 1, 2, 4, 5, 7 jury members out of the herd and make them sit down and fight and say the only reason we're here is because of what the kid did and because this is gun related, so let's not convict the dad. And we're going to hear that expressed in multiple different formats throughout this presentation of the defense's case, as well as through the remaining examination of the state. We're going to see a lot of issues coming from the defense, like you said, about poking through the knowledge and notice that the state is relying on. Colin Gray can only be held responsible based on what he knew. If the state has over curated their belief involving notice, that could really flow against the state. It could make it look like this is a setup, that this is selective prosecution, where this would have never been a case outside of the unique circumstances which developed. A lot of the discussion outside of court centers on the fact of how this incident would play out in the speaker's community. And I have people that live in urban areas, rural areas, suburban areas, and really, many people are shocked at how the initial police-citizen encounters went because they're not used to that kind of police relationship. Many people are focusing on what the obligations of the school should have been because this child was, for lack of a better term, run out of schools and was a known substantial concern of school members. But what did the school do? Well, that gets into the discussion about school immunity. And the fact is that since schools are impossible to sue in Georgia, they are literally protected by a constitution, there's no market incentive for schools to take the appropriate proactive actions to protect their kids. Because they know,
and that, Joshua, that would be a point that likely some would raise in the courtroom. I'd be remiss if I didn't point out, I'm sure Georgia school systems would push back on that claim. But you're getting at something I want to tease out and ask you about a little more from a legal analysis perspective. As you watch these proceedings, we're now 5 days into the testimony at this point. Is it going to play out in your expectation on some level that the state is, with every piece of evidence introduced, with every witness, trying to narrow the scope of the focus of the jury down to a relationship of responsibility between the father and the son, and the defense will be doing all it can to widen the scope, to point to all of the other people, adults, institutions that were in this young person's life who perhaps also had some warning that there were some troubling signs and also did not, perhaps, the defense would argue, do enough to prevent the ultimate outcome.
Yeah, the defense certainly has that almost apportionment argument of, listen, dad made some terrible choices. I get it, but it wasn't just dad. It takes a village. We can't just criminalize dad because raising kids is hard. And where's mom? And where's the other family members? And where's the other rest of the... That is a logical connection that some people are going to struggle with when it does take a whole community of people to notice the behavior issues with Colt Gray. And then absolutely they're going to question, well, why didn't somebody else do something? Now, we all know that parents are parents and parents get to raise their kids. And certainly parents don't like other groups, individuals, certainly the government, coming in and telling them how to raise their kids. So you've also got that issue with how should a citizen react when a government agent reporting from other government agencies advises you about your child. While many people would welcome that kind of input, some people would automatically be cynical and suspicious because it comes from a government source, and they view the interference of the government in their private lives to be very offensive. And that's a delicate line that the state has to walk in showing that, hey, if we're going to make Mr. Gray criminally responsible for his son's actions, what do we need to prove to satisfy the jury that the community did enough, put him on enough notice, had told him enough times, man, your kid's going to be a problem, you need to do something about it. And that's a gray area. There's not a bright line rule of, well, after 4 letters, you're now on notice. Nope, that doesn't exist.
And Joshua, in the legal system, when we talk about negligence, which from a layman's perspective at least, is sort of a core component of this conversation, negligence tends to play a more frequent role in the civil side of our justice system and in tort law. Here we're talking about the criminal justice system, and the criminal code has a little bit of a wariness, generally speaking, for criminalizing the conduct of another. In other words, blaming one person criminally for the conduct of another person, right?
Well, the vast majority of criminal charges require something called the mens rea or intent. You have to choose to take an action. Now, that action, is it criminal or not? That's the question in criminal law. Whereas you're right, negligence doesn't have that intentional portion. You don't mean to cause a car accident. It happened due to your negligence. And criminal negligence is traditionally disfavored. As well as, like you aptly put out, we don't like holding people responsible for what third parties do. If we're going to do that, we need a specific statute in order to allow that, such as conspiracy or RICO. There are laws very specifically written that would then add co-defendants, co-conspirators to an original claim. Here, that's not happening. We don't see Colt Gray charged in conjunction as a co-defendant with his father. No, Colt Gray's trial is completely separate and distinct. It will be held after his mental health evaluation comes back sometime later this year. But Colin Gray's trial is completely independent of that. The negligence is interesting because when it comes to the appeal of this case, that's certainly going to be one of the parts the defense is going to lean into, is how the mens rea requirement for criminal prosecutions has been satisfied, or whether it was necessary to be satisfied under this particular state theory, traveling under the cruelty to children. And we'll have to see, man. Smart people are going to spend a lot of time poring over precedents, poring over prior arguments, showing the court how the courts previously treated these kinds of issues in an effort to get them to firm that up when this case reaches appeal.
A case with a lot of thorny legal issues, issues of first impression in front of a Georgia judge and jury, and at the heart of it all, a terrible tragedy, the killing of 4 people and injuring of 9 others at Apalachee High School. Joshua Schiffer, we always appreciate your perspective, your analysis. Thank you very much, and we will talk to you again, I am sure, as this trial continues. Joshua, thanks.
Thanks so much, Zach. I hope everybody has a great weekend, and thank you for covering this. These are the kinds of cases that really move our state forward, and it's incredibly important we as a community are educated about how this system operates. So I really appreciate you bringing your journalism and integrity to exploring this process.
We appreciate it, Joshua. Thank you. And we will continue.